let's get to the Interception of Communication Amendment Bill 2020. Now, this is currently being debated as well, right? Correct?
Well, I can give you the stages. It was passed in the Senate.
Right.
Then it reached the House last week, Friday. There were some amendments made in the House of Representatives.
Right.
So those amendments will now be considered this morning in the Senate.
All right. Those amendments will be considered this morning in the Senate. Now, what I want to find out, and I think for the knowledge of the public, is simply this. What does this bill actually serve a purpose for? Because we've heard it's about interception mainly of prisoners and you know, along the lines of prisoners, you know, making phone calls from the prison and having cell phone in the prisons. And I heard the bill being somewhere along those lines to serve a purpose of intercepting that information in order to, so that the police can act on these conversations that are taking place. There's also a concern that it's going to affect journalists and lawyers as well. I heard the opposition leader say that. Now, I know that specifically because Dr. Rudal Munilal mentioned it in the Parliament yesterday in his contribution, Friday, in his contribution, where he spoke about stored data. So let's just go through this bill and kind of just educate people on what this bill is about. So just explain me what the amendments are about.
Okay, let me just give you a minute of the brief history of the bill.
Okay.
In 2010, we had the Parent Act being passed, which is the Interception of Communications Act. That was passed at a time when we discovered that the state was using its apparatus to spy on its various persons. You remember that they were spying on the president of the country, several politicians, even comedians, journalists.
Okay.
They were being spied on. So at the time, the People's Partnership government understood that there needed to be some protection from the state spying on persons. So therefore, this bill was passed in order to ensure that that doesn't happen again. And also it balances the need that intelligence is important when you're going to fight crime.
Right.
Now, the Attorney General came to amend that 2010 Act. And in that 2010 amendment, there are certain amendments being placed. And we must put this into context of the Parent Act. Okay. In order for there are three authorized officers under the Act. It's the Commissioner of Police, it's the Chief of Defense Staff, and the Head of the SSA.
Right.
They are the only three officers who can intercept or authorize their officers to intercept. So, as the law stands now, in order to intercept someone and admit that intercepted communication into evidence in a court, it must be done through a warrant. The proposed amendment is that it removes that requirement for the police, for the SSA, or the Chief of Defense Staff to get a warrant. So they can intercept my communication right now, my call with you. They can intercept any single call in Trinidad and Tobago, admit that into evidence without a warrant. So that is the danger. Because when you look at how stringent, how the matters that a court looking to consider when granting a warrant, you'll see how strong it is. And one of the criteria the court looks when granting a warrant is whether or not this is the last port of call. You must have used all other methods in terms of an investigation before you intercept, because it's a very intrusive, invasive method. It's a clear breach of your privacy. If the state is listening into your phone calls, now it contemplates stored data. So we're looking at messages, we're looking at text messages, we're looking at emails, we're looking at social media. One may even ask whether or not this would affect your banking information, because a lot of persons do online banking, which is a form of communication with your phone or computer to the server of the financial institution, which would also constitute some level of stored data on your end of the device.
Okay.
The Attorney General wants you to believe that this is going to only affect prisons and prisoners. That is not true. It is affecting every single citizen, journalists, attorneys, ordinary citizens, any person who has some level of communication using phone, computer. They are liable to have their communication intercepted and admitted into a court of law without a warrant. Now, it's very simple. If there's a problem with cell phones in a prison, last year we made it illegal for any prisoner to have a cell phone in prison. Why not turn on the grabbers and the jammers at the prison if you're seeing that cell phones are causing an issue?
Okay, but you said last year they made it illegal for prisoners to have a cell phone?
Yes, there was a miscellaneous provisions bill that made it a criminal offense.
But wasn't that illegal before?
Well, it kind of amounted to some level of breach of the prison rules, but now it's an offense. So if a person has it, they can face a magistrate in order to prosecute it.
Wait, let me get it straight. Only last year it became illegal to have a cell phone in a prison?
Yeah, it's illegal contraband.
Okay. We're moving on. We're moving on now. We're moving on. Go ahead. In terms of stored data, you mentioned text messages, emails, so on and so forth. And I just want to explain to the people. I want you to let me know if I'm on the right track here. Let's say I have a personal conversation with someone I'm close to, and I snap a picture and send it to them. Can they access that if they wanted to?
They can, because it now will fall under the definition of stored data.
Okay.
And they can do it without a warrant.
And they what?
So they're doing it without a warrant, so no protection to the ordinary citizen.
So they could just access it just like that? Go into a server and access it?
Yeah.
Okay.
So now with respect to the specifics of the apparatus available to national security, those are things we can discuss over the air in terms of how the communication is intercepted.
Okay.
But there are two other points that we have to look at the bill. There's also an addition to the amendment that Faris Al-Rawi has now introduced, which is called a special advocate. So the state takes all of your communication, they intercept it, they admit it into court. Now, because the information may be sensitive, they're telling you as the accused person that you and your attorney cannot sit in the courtroom when the court is going to decide on this evidence because of its sensitive nature. So the state, who is prosecuting you, is paying for an attorney called a special advocate who will seek your interest, who you are not giving instructions to, and who you are not paying. So that is the system that this government wants to set up, called a special advocate.
Wait, hold on.
Now, that is...
Hold on. Let me just see if I got that there. You're saying that I hire an attorney to represent me.
Yes.
Now, first off, in terms of attorney-client privilege, if this bill is passed, then that's out the door. There is no attorney-client privilege?
Well, once they intercept your call, an ordinary call, they can listen to what you're talking to the attorney about.
Okay. So, I hire an attorney, but in the court, you're telling me that the state will provide an attorney to serve as what? A middleman or woman between my attorney and myself?
No, to represent you.
The state will hire an attorney to represent me?
Yes, called a special advocate.
Okay, a special advocate attorney. Okay, but where does that put my attorney that I'm dealing with?
So both of you and your attorney will not be allowed in the courtroom because the information they indicate will be sensitive. So therefore, you and your attorney are not going to be part of the proceeding. They will appoint an attorney for you to determine and look at the evidence of what they intercepted. Yeah. And then that attorney will be seeking your interest, but you would not be given that. You don't have a relationship of client-attorney relationship because you're not paying.
The state is?
The state is, you never hired the attorney. There are certain levels of instructions that he will be able to get from you, and there's only limited information he can give to you. Because at the end of the day, his duty is to one, to the court, and two, that he protects the sensitive information. Right. So you may very well be prosecuted for an offense, and you don't know what the evidence is against you. Because some third-party lawyer the state hired is going to determine and only be able to view that evidence.
Wow. I did not know that in terms of that bill. I did not know that. All right. Now, there is a 3/5 majority that was needed to pass this bill. But they have removed that 3/5 majority. Now, first off, I think people get the gist of the bill and the dangers of the bill, or the concerns about the bill. But let me just for informative purposes, if we could just explain to the viewers what a 3/5 majority, what is the purpose of that? How important is that in terms of these sorts of decisions in passing a piece of legislation? And when removed, what does that mean in terms of that 3/5 majority? What does it open up in terms of the decisions and the legislation that is before the House?
Okay, so the first question you ask is what is the purpose of a 3/5? In the Constitution, you know that there are two houses of Parliament. There are certain fundamental rights and privileges that are listed at Section 4 and Section 5 of the Constitution. And once you breach any of these rights, the Parliament is required to pass legislation with a 3/5 majority. And that is a protection that was inbuilt by the drafters of the Constitution, because you don't want any government to just abuse citizens' rights and take away their rights without the parliamentary protection.
Okay.
So those 4 and 5 rights that I spoke about, Section 4 and 5, are certain rights like the right to due process of the law, protection of the law, the right to life, the right to privacy, the right to property. Those are some of the rights.
Okay.
And once you touch or breach those rights, so for example, in this particular bill, you're breaching your right to privacy because the state is listening into your private conversation.
Okay.
So therefore, a special majority is required.
Okay.
Now, the Attorney General was able to garner a 3/5 support in the Senate. The government voted for the bill. The opposition voted against the bill. The independent senators, 8 of them voted for the bill. 1 senator abstained.
Okay.
When the bill went to the House of Representatives, what we saw there is that the government, in order to get the bill passed, because the opposition didn't support, they removed 3/5 requirement.
Okay.
So now the bill is now into what we call a simple majority. So all they required was the votes of the government members. Now, that is dangerous because the Attorney General himself admitted that this bill infringes on constitutional rights and freedoms.
Right.
Hence, he put the 3/5 majority in the Senate.
Okay.
And all of a sudden, you remove it just because you want to pass this particular piece of law. Now, what this does is that it causes the bill to be vulnerable. It causes the bill to be susceptible because if any person files a claim in the court, they can strike down the piece of legislation based on the fact that it was not passed with the required majority.
Oh.
Now, there's a technicality in the law where the Attorney General could argue whether or not it's proportional. But there are certain distinctions you have to make here because the types of rights that you are breaching, which is the right to privacy, the right to your attorney, the right to protection of the law, the right to a fair trial, the right to due process, those are very fundamental rights.
Yeah.
Is that you can't just remove a special majority because the special majority really is reflecting the will of the people because it requires the support of the government and the opposition.
Okay. So once that is removed there, it's more or less a formality that this bill will be passed.
Yes.
Okay. Now, are there any? Okay. But even in terms of the interception of communication, just real quick here before we wrap up, and let's have a few moments. So if you could explain this one real quick. What is the opposition's position? Is it that you all see the bill and will not support? Is it that you won't support the bill in its current form, or you won't support the bill at all, even if there are some amendments that or some recommendations you might put forward, or have the opposition put forward recommendations for this bill?
Yeah.
Many of them were taken into consideration, or many of them were rejected.
So in the Senate, we did in fact at the committee stage wanted certain amendments. Those amendments were not allowed per se. We did have some discussion at the committee stage. Also, we cannot support this bill in the current form. After the dangers I would have outlined in terms of this advocate, in terms of the warrantless interception of communication, in terms of this applying to every citizen and not just criminals.
Right.
So we can't accept that because we at this late stage of the parliamentary procedure. No more amendments can be made to the bill.
All right. Well,
we're just considering the amendments in the House of Representatives.
Okay. Well, I think we covered a few things well on the bill, but I'm just about out of time for you. But we will resume this conversation as things go along, and now I'm better educated on the bill and what the bill provides for the authorities that would infringe on the privacy of people. So we'll find out what the public thinks about it. And I want to thank you, of course, for taking the call and being part of the program. Senator?
Thanks very much.
All right, no problem. We'll chat again soon.
Sure.
All right. So that is Senator Hosein.